So I would ask, I think trust is an important element. Some forms of governance assume trust. So Wikipedia, for example, one of the main principles in Wikipedia as a project is that you have to assume trust, that you trust everybody. But then if that doesn't pay off, you might have to come up with another solution. So we will keep an eye on this, and if we continue to have trouble with getting everybody into the room, then we'll have to come up with some solution. And I hope as a community here, we will come up with a solution that everybody finds acceptable, keeping with the ethos of the internet, etc., etc. So over to Pranesh, Prakash now, to give us a 50, Pranesh, please don't go over 5:30. So, 6:30, sorry. So 50 minute quick run through of copyright.
Okay, so how many people have seen this before? So, well, this is the original one, and this also has been parodied multiple times. So the name of the painting or the found art, actually, it's not quite a painting, is written right there. But who did this? Sorry? Huh. Sure. The original most probably was done by an Italian artist called Leonardo of Da Vinci. So, but who did this version? Any idea? Okay, this is a French artist who decided, who got a postcard, a bad postcard copying Mona Lisa, and drew a nice French mustache with a small beard and just wrote the title over there. Now, most people, when they see this, they think about parody, they think about art, they think about found objects as art, etc. When I see this, I very, very unfortunately only think about the fact of when was the Mona Lisa painted. Oh yes, it was sometime in the early 16th century, so that means this is in the public domain. And so people are actually able to do things like this with the Mona Lisa in a way that you aren't able to do, and people have been sued for doing with something like Mickey Mouse. Okay, so that for me is actually one of my introductions to copyright. I, at one point of time, sometime around 2001, I think, found a website called illegalart.org. It had lots and lots of illegal art, but all of it was art that was illegal because of copyright reasons. Okay, and I found that quite fascinating, and I, at that point of time, started reading up a little bit more about copyright and what kinds of problems that it presents, and that's how I got into this field. Okay. Oops. Just give me a second, sorry. Okay, copyright and access. So, how many of you think, you're lawful citizens, by and large, I'm presuming. How many of you think you've not violated copyright law? Put your hands up. So you wouldn't generally have. How many of you have pirated software? Okay, that's a large number of people, so all of you are out. Okay, and how many of you have, so basically how many of you have not done stuff other than pirating software? So by and large, you should have stayed clear of copyright law, right? Those of you who haven't pirated software. Like, so have you pirated software? Okay, then why do you think you've violated copyright law? Movies and okay, books. Excellent. So all of us have violated copyright law at some point or the other. What is the punishment for violating copyright law? Do you get to say sorry to the creator and get away with it if the law catches up with you? Sorry? Paying for it. That's one possible solution. Well, what the law in India says is that you can be put in a jail for 3 years for every single instance of violation of copyright. And each one of us has violated copyright multiple times. Okay, and so exactly. So let's look at the kinds of things that might be violations of copyright. So all of us who've been, I'm guessing, at least to university, okay, have at some point or the other photocopied an article. Okay, any of you hasn't at all photocopied anything? I'll get to that later. Has any of you photocopied an article? Or sorry, not photocopied an article? Okay, excellent. Whistled a tune. You can't whistle. Excellent. So you're clear of that. Fantastic. Have those of you who haven't, who can't whistle, have you sung a song ever or tried badly to? Okay. So you're covered by copyright. Have any of you replied to an email? Okay. So did you take the permission of the person who wrote you the email before, sending them that reply, or before sending that to a mailing list or something? Have you? So how many of you have ever used mailing lists? Okay, so most people here have used mailing lists. Okay, did you take the permission of the person whose reply you copied in your email before sending that out? Why not? So before replying to a mailing list mail, you actually took the permission of the person who. Excellent. So you're clear of copyright law in that instance. But I think you're probably the only person in the history of the world who's clear of that. Okay. Have any of you ever browsed, to a website? Have you ever gone surfing online? Okay, everyone has. And that means on your browser, there's a cache that's created. That means in your RAM, there's a temporary copy that's created. And interestingly, this one I didn't mention earlier, but it might also be a violation of the IT Act, because Section 43 of the IT Act says that before you download anything or before you create a copy of anything, you need to take the permission of the person. And this is the provision on hacking. Okay, you need to take the permission of the owner of the computer resource. So if you want to liberally interpret it, that means every time you visit a website, before doing so, you need to take the permission of the people who own the website. And till very recently, the National Informatics Center, in its hyperlinking policy, said before you link to any of our websites, you need to take our permission. Okay, they apparently didn't know how the World Wide Web was invented by mixing internet and hyperlinks the way you guys do now. So, okay, have you ever thought about why digital libraries don't have new books? So how many of you have ever used a digital library? What library is it? DLI, the Digital Library of India. How many of you have used DLI? Oh, interesting, a few people. I found out about it very recently. What other digital libraries have you ever been to? Europeana? Sorry? LibGen? That's a very interesting example. Project Gutenberg, anyone? Okay, some people have been to Project Gutenberg. Internet Archive. Internet Archive, lots of people. Sorry? Okay. So, uh, sure, you can include that. So, my point in this is that if you look at uh, there are some libraries now that's that also lend ebooks. Okay, but how do they lend ebooks? They lend it to you with a device. Okay, so on a, so you it is bound to a Kindle or it is bound to a device, and these aren't prevalent in India so far. In India, we just go online to Book OS, LibGen, and Project Gutenberg and things like that. Now, things like Book OS and LibGen actually under the law are illegal. Okay, and Project Gutenberg, Internet Archive, etc. Okay, the books that they can have, okay, are books that are out of copyright, meaning really old books. And that's also an interesting question to think about. Why digital libraries aren't possible? Uh, and I'll think about, while you're thinking about that, also think about the fact of when libraries came about as a concept, public libraries. What are libraries at the core of it? You know, they buy one copy of a book and they allow multiple people to read that copy of a book. Think about that for a minute. Isn't that the biggest copyright violation in the world? You know, instead of buying, 50 copies, okay, if you bought one copy of something and 50 people read it, they would say it's copyright violation. But why should a library be allowed to do it? The only real reason why a library is allowed to do it, whereas you, for instance, if you screen a film without taking permission, okay, why that is illegal on the other hand, is because libraries as a concept came up before copyright became ridiculous. Okay, and what we have today is a very ridiculous kind of copyright. Okay, and I'll come to that a little bit later as to what has changed. But the fact is, copyright wasn't always what it is today. Okay, which is a barrier to access in very many cases. Okay. Sure, but libraries have been grandfathered in a way. Okay, libraries existed before copyright was the strength of nature that it is today. Okay, the force of nature that it is today, and so since libraries existed, have been existing since at least public libraries at least since around the 1850s onwards, and there was a library movement, etc. So libraries are allowed to exist. But if you think about it, at the heart of it, at the very core of the function of a library is violation of authors' rights. Buying one copy of the book, not 50, but buying one or two copies of the book and allowing many people to read it. Okay, and the fact is that wasn't and hasn't always been considered a horrible thing. Have you ever had a book read out to you, either as a child or because you're a blind person? And I'm guessing most people, the answer is yes. Okay, and well, recently in the US, the Authors Guild of America, okay, filed, sent copyright infringement notices to Amazon. Amazon in its Kindle, okay, just as if you have an iPhone with Siri, with other kinds of, voice, text-to-speech engines, in the Kindle there is a text-to-speech engine. Okay, the Authors Guild of America believed that this could lead to infringement of the audio editions of their work. A mechanical voice reading out something, and this is very important for blind people, okay, could be an infringement of audio rights. Okay, and Kindle now remove that function and only allows it if the publishers allow it to be there. Okay, so it's not available across all books. It's only available on select books now. Okay, and available on all kinds of other things, and as Sunil pointed out, many people with low vision impairment, low vision and other kinds of vision impairment rely on that kind of a feature. Okay, yet in this one, and screen readers have existed for a while now. Okay, yet the Authors Guild of America now decided to make this argument, and Amazon decided to give in to that argument. Okay.
Houses as well had audio versions of the book as cassettes. I remember listening to the cassette and looking at the book, like Ladybird.
Those would be done with permission. Those would have been created with the permission. If you go to LibriVox.org, okay, you will find lots of audio editions, but all of those would be for public domain works. Okay, so.
I just wanted to ask if they're rendered into braille versions, will that be a violation of copyright too?
Until recently in India, yes. Okay, but now in India we have an exception. Okay, and it was an exception that was introduced last year. Okay, so the fact is, so my point in all of this is, and all the examples I've taken, okay, are things that have been except for replying to email, okay, are things that have been litigated at some point or the other. Okay, even RAM copies, okay, copies of something of some software or something else that's loaded onto RAM as a temporary copy, is something that in the 90s went to courts in the US and was litigated upon. And actually there are courts that have held that even copies that are created in RAM, okay, are copyright infringement. Okay, so I've not made this list up, but I've just trying to point out how a lot of it is very ridiculous. Okay, and yes, as Professor Arunachalam pointed out, there are exceptions. But lots of countries don't have an exception for education which covers photocopying. In India, we're arguing that it does. Okay, in India, I think the law pretty explicitly states that you can. Okay, but in lots of countries, they don't. India, surprisingly, and I think India has a bad educational exception, but when we did research on this a few years ago, looking at multiple jurisdictions, what we found was India actually has one of the most progressive educational exceptions. So think about how it is in the rest of the world.
In Delhi University, very recently there was a person, like a publisher, tried to sue a local photocopier for photocopying books and delivering it to the masses. So I don't know how that can happen if India has the provision of photocopying in its law.
So that's precisely what the dispute is about right now. In India, the educational exception allows students and teachers, okay, to make use of that exception. Okay, and that clearly includes uses the word reproducing. Okay, so it includes photocopying. What they're saying in that case, okay, and that is a beautiful case to focus on. Okay, to think about the fact that all of us have violated the law according to the publishers. Okay, that just because it was a photocopying shop which has which is under a license with the university and can't charge anything that it wants, the charges are also set by the university, is treated like some kind of outsider to this process of education. Okay, and we all know that it is an integral part of education. Okay, yet it is treated as some kind of outsider, as some kind of business making money out of the misery of these publishers, which are primarily Oxford University Publishing and Cambridge University Publishing. Okay, so they're the ones who filed this case. So, and that I think is something that should concern all of us, because we've managed to make it through the system, you know, relying on these kinds of exceptions. But now there are more and more challenges to these exceptions. Okay, and India again is one of the countries with the largest list of exceptions, but so many of the things that you do on a regular basis still will not be covered by these exceptions. Okay, So the educational exception, for instance, does not cover digital education, does not cover distance education in my reading of the law. Okay, so there are still so many problems. I hope to keep my talk short, so I'll run through this a bit quickly. But why copyright? What is the purpose of copyright law? Okay, generally, people use one of two reasons. Okay, that either it's to reward artists and promote originality, or they say it is to protect authors' rights, that because it is something I've created, okay, it somehow belongs to me. Okay, so one is an incentive theory, that it is to incentivize the creation of arts. Okay, and the other is the theory that is the more property based theory, that it somehow belongs to me. Now the first is an idea that, and the first is also the more prevalent theory in especially in countries that follow the common law, that is Anglo-American legal system. Okay, that copyright is meant to benefit both the readers, viewers, listeners, and the creators or producers. Okay, that is not meant only for the creators or the producers. It's actually meant for the public. Okay, as something that results in more and more production of works. Okay, it's supposed to be an incentive system, right? So to get better quality and to get more works into the public arena is the main purpose under this theory of copyright. And in more or less explicit words, if you go by the American Constitution, which actually contains a clause on copyright, okay, that's the purpose of copyright law. And very importantly, if you remember Professor Arunachan talking about standing on the shoulders of giants, right? That, in a sense, tells us very succinctly that producers are also consumers. Okay? There is no artist who has ever lived who has created something in a void. There is no writer who has ever lived who has created something in a void. No one, none of us ever create things in a void. Okay? All ideas come from previous ideas and are built on other ideas. The idea of the special theory of relativity, okay, is an idea that comes and especially the general theory of relativity is an idea that is built on many decades of ideas that existed before it. Okay, that multiple people worked towards at the same time even. Okay, and these don't exist in a void. But the interesting thing is the copyright system treats it as though they do. Okay, the copyright system creates this kind of distinction that places creators on a pedestal and the rest of us, okay, on another pedestal, as though all of us aren't creators. Okay, and the point where this conflict really starts emerging is with the digital. Okay, is when not just a few people are publishers, but all of us are becoming publishers. Okay, that starts causing a big problem. So while copyright law has existed for many decades in some countries, for many centuries in other countries, through all this time. So so the simple question: if copyright has been a problem, okay, then why, how has knowledge, access to knowledge, actually progressed? Okay, the answer is copyright hasn't always been the same problem that it is now. And very importantly, copyright, the way it exists now, okay, especially after things like the Berne Convention and the TRIPS agreement, is a one-size-fits-all system. And please do interrupt me if you have any questions. Okay. So what so the question becomes, sorry, I think I have this thing missing. Okay. So one point missing somehow. Okay. Which is a question that I had. Should the copyright cover a blockbuster film or something that someone hopes is going to be a blockbuster film, on which producers sink in, you know, crores and crores of rupees, the same as a tweet that you send? And should the tweet that you send out be treated the same as, you know, a 500 or 600 page tome that you write? Copyright law, very unfortunately, doesn't distinguish between all of these. It treats all of them the same way. Okay? And the fact is, till recently, okay, in the history of copyright, it's not always been that everything that is written is copyrighted, which is the case now. Okay, so how many of you know, or like knew before I told you, that you don't need to register copyright in order to have copyright? 1, 2, sorry? Or, yeah, register with the government or anything, that you don't need to do that in order to have copyright. Yes. So how many of you knew that principle? A few of you did, not everyone. Okay? It provides evidentiary backing in courts. Okay, it's not needed at all. Okay? So, but that wasn't always the case. At an earlier point in time, it was the case, for instance, in the US until 19, actually I can't remember, but sometime around the 1960s, I believe, that it was only upon registration that you got copyright. Okay, and that, for instance, is an important
point of view. We are doing what's called a watershed project. And the watershed project, the state government of India has it in 2 languages. The state of Andhra Pradesh has it in English. Watershed is supposed to be a community issue. And both the websites that have been created are like MIS systems. They are not like do-it-yourself. But there's a lot of material in YouTube which tells you what watersheds is, videos, everything. And then we studied the issue. And then we found that there were 2 types of copyrights. I mean, when you put it on YouTube, you could either put it on Creative Commons or you could put it under YouTube standard license. No, so what we decided to do is isolate all these things, and Creative Commons, anyway, whatever, which version of Creative Commons, and then remove the English script and put the Telugu script. But what we felt was, like what you are saying, many people, when they upload, we have not actually gone through that process. But I am imagining that when I put something on YouTube, and then there's a question mark which comes, what do you want to do? So it's very safe to say standard YouTube license. And
so
when
that's the point I'm coming to.
And the point is, you really don't know the implications of standard YouTube license. So, and then Google prevents you from writing to those authors directly. So you only have to write to them through Google.
So that's kind of the point that I'm trying to make, that lots of people, okay, might not actually want. Now, the Creative Commons system was designed precisely to address this one-size-fits-all problem. Okay, Creative Commons, for those of you who don't know, okay, and there should be one poster here which explains Creative Commons also, okay, is a system, okay, which allows you to cherry pick what amongst a few different features of copyright. It allows you to say whether or not you want to allow for derivative works, okay, whether or not you want to allow someone to reuse it in that fashion, whether or not you want to allow someone to use it for commercial purposes or not, okay, and And there's a standard which is that always you get attributed. Okay, so CC, BY, ND, NC, and the last one is share alike. That if you're using this work, okay, please give other people the same kinds of rights that you've been given. Okay, so you can mix and match between these different combinations. Okay, between these different features. Okay, and that still doesn't, allow you to say, wait a second, I don't want copyright beyond my death. Okay, so how many of you know what the term of copyright in India is? How long does your copyright last? Any guesses? Sorry? It depends on what? Not quite. I'll come to those differences in a minute. 100 years is one guess. It depends is another answer.
40 or 75?
40 or 75 guesses. 60 years from when?
From the time of production.
From time of production. Okay, you're excluded from this. Okay. Forever. So in India, the standard copyright term, with the exceptions, okay, is life. So is 60 years from the moment you die, or actually from the 1st of January after the year that you die, to get really technical about it. Okay, 60 years after you die. That's how long copyright lasts. It's not counted from when it is produced. Okay, photographs until very recently were counted from the time that they were produced for 25 years, for 60 years. Now even photographs are counted with the most recent changes in copyright law are counted from the moment that the photographer dies. So think about things like the Indian Memory Project, which is an online website, okay, which uploads old sepia photographs online that people submit to it. Okay, and they host it, and there are generally small stories about the people in the photos, etc. So photos basically of your grandparents, of our Rajas and Maharajas and stuff. Okay, so those kinds of old time photos, except that now suddenly that entire project is put into a gray area, legally speaking. Okay, because the people who are submitting the photos, they generally don't have copyright, because the people who click the photos do. In many cases, in most cases as a matter of fact, they don't know who clicked the photos. Okay, and when you don't know who clicked the photos, you don't know when they died. And when you don't know when they died, you don't know how long 60 years from when they died is. So you don't actually know till when copyright lasts. And if you don't know till when copyright lasts, what's the smart thing to do, if you don't want to go to jail for 3 years, is to not use it. Okay, so this creates a whole lot of problems for things like the Indian Memory Project, for things like Wiki Commons, etc. Now, what are some of the changes in copyright law? I've spoken about one, which is that copyright term is increasing. So any guesses as to when the first copyright law came in, how long the term was? Any guesses at all? Around 1709, 1710, what the term of copyright was in the UK? 10
years.
10 years? Any guesses? Okay, so the term of copyright then in 1709 was 14 years. Okay? And it was extendable to 21 years, with another 7 years. Now, somehow, the material produced today is apparently much more valuable, okay, to a person, to an author, okay, and is much more valuable to society, it seems, that you need to protect it beyond their death. Because, they're counting all the money they're getting from, heaven or hell or wherever they are. So, and that is a big, big change. And a lot of the increases that we've seen have actually happened in the past century. Okay? And so that's a big problem. that now copyright lasts longer than it ever has in the history of humankind, and it doesn't look as though it's going to go back, okay? Because there are international treaties now that provide a minimum period for how long copyright can last. They don't provide a maximum period. And in fact, there's an interesting story about how in 1996 you had a situation where there were rumors that in Europe, okay, copyright was going to be extended, and as it happens, around 1997, okay, was when the copyright on Mickey Mouse was going to expire as well. Okay, now as we know, Mickey Mouse is a very, very, very popular is a good word for it, product. Okay, and is a very valuable commodity for the Disney Corporation. So just when copyright in Mickey Mouse was going to expire, there was a huge amount of lobbying in the US to get the term extended. And one of the arguments that was used was, in Europe they're thinking of extending the term, we must, we must do that as well. Eventually, in 96, it was extended. Okay, a large number of, I think around 12, actually I'm forgetting, I think 12 Nobel laureates, okay, wrote a paper. 12 Nobel laureates and more economists altogether wrote a paper, okay, talking, explaining how meaningless this was, how it was not going to incentivize anyone to create works, okay, if knowing that it's going to last a little bit longer after their death, okay, nor is it going to somehow benefit people who are already dead, well, because they're dead, okay. So yet all of that was rejected. Now in Europe, they saw that this was increased, and so in Europe the lobbying began saying, see, in US they've actually increased it, so now we must compete, we must also increase it. And the same thing happened in Europe, okay. So, and in India it's even more beautiful. In India no one lobbied to have copyright in photographs extended, yet copyright in photographs was extended without any lobbying. So so it just shows how forward-looking the Indian government is. So length of term is increasing. What is oh, sorry, I missed the first one. What is copyrighted is also increasing, right? So with the changes in technology, new kinds of media are being invented, okay? So think about it. First there was print, okay, and one of the reasons copyright came about was because of the printing press, okay. But then came photography. Now why are photographs given copyright protection? Because aren't photographs themselves copies? There is something that exists, you're putting it onto, something else. Nowadays it's a digital file. Why? For when you photocopy something, you don't get new copyright over the paper, right? But over photographs, you do. Because after many decades after the first cameras were invented, okay, they decided that photography is not only mechanical reproduction, but there is some kind of artistic thing also that's going into it. Whether there is or not is something that's debatable.
Does that mean the book I photocopy is also protected by the copyright law, by that standard?
No. Okay, you are an infringer. A camera person is a creative artist. Okay, so now that actually is an open debate. Okay, and the opposite is also an open debate. So in Wikipedia right now, there is a debate going on about whether someone has made a scan of something that's in the public domain. Can you put up the scan on Wikipedia or not? Is the scan, does it have independent copyright or not? Someone takes a photograph of something that is in the public domain and no longer has copyright. Is that photograph, does that have independent copyright or not. An internet archive, for instance, they don't use scanners. They use two cameras located to do all their scanning. Okay. Now, does that have independent copyright or not? Can the Internet Archive then go ahead and sue someone else, saying, wait a second, even though what we photographed was in the public domain, but we have new copyright on it. Okay, so this is the kind of stuff that keeps people like me rich. Okay, but the thing is, oh, I really wish I was a practicing copyright lawyer. But the fact is that new kinds of media are creating new kinds of complications in copyright law. Okay, now when photography, okay, gets within the fold of copyright, it's still the person who takes the photograph who's provided copyright by default. But there is but when it comes to films and when it comes to sound recordings, okay, that somehow changes. Okay, so previously we've had three kinds of things, right? First we have literature, then to that gets added musical scores, etc. Okay, and after musical scores, okay, which are also at one point treated as a form of literature, okay, because it's written down in the Western tradition very often, okay, and then comes photography with the photographer, okay. But when it comes to films and sound recordings, somehow it is the person who puts in the money who gets copyright and not the person whose idea it is. Okay? And we must remember that by this time, by the time these later categories get included into copyright law, okay, the industry, okay, the copyright industry and the what Adorno and Horkheimer call the culture industry, okay, is much more prominent, okay, and eventually so they manage to actually get themselves the rights rather than those who might be seen as the creative creators. It's the monetary producers who get these rights instead. Okay, and then of course we have a situation where in the digital world, okay, everything is a copy. When a file is transferred to you, a copy is made. When you move a file, the file is copied and the original is deleted. Okay? So everything you do online, everything you do with the computer, everything you do with anything digital automatically creates copies. And what is the one thing that copyright law prohibits? Creating copies. Okay, so you see that with digital, everything, you know, the entire concept of the digital is almost outlawed by copyright law. And there's a fundamental problem between the digital world and the world of copyright that to date, lawmakers have not really addressed. And there's one other aspect of the digital world that has a big impact, as I pointed out earlier. Many more people are shifted from categories of consumers to the categories of consumers and producers. Okay, so there's a fascinating paper by Lawrence Liang in which he talks about Wikipedia before the age of Wikipedia. Okay, and the internet in the 15th and 16th centuries. Okay, you must read that, but he talks about how collaborative writing is not really a new thing, is not really something that comes about with Wikipedia, but existed even without people really realizing it in many cases, existed far before that. But now we come to a situation where, forget about instances of that amongst the cognoscenti or amongst people who know how to write, or at least scribes who know how to copy. Now it is everyone who can actually participate in this. Okay, and the literate, the neo-literate, the illiterate with voice recordings, everyone actually can participate in challenging copyright in this very difficult way. Okay, so this, I'll end here. Okay, and we spoke a little bit about challenges to access, but I wanted to point out that just separating access as a separate question, okay, as you know, thinking in terms of access to medicine is not the right way of going about it when you're talking about access to knowledge. Okay, access to medicine is a clearer question. Okay, you can, like, you know, you have a disease, you need access to medicine. Access to knowledge is not that kind of a clear cut question. And the fact is, access to medicine isn't a situation where you're both a creator and a consumer at the same time. Okay? Whereas copyright is, everyone creates copyrighted works on the basis of stuff that has existed earlier. Yet we get new copyright over it. So I like purposely left out the question of access, so didn't just want to make it about, you know, access to textbooks in poor countries, etc. But wanted to point out that there's a slightly more fundamental shift. Of course, access to textbooks in poor countries is a huge issue. Okay, but in those issues, copyright law might not be the most important thing. Okay, in those kinds of things, it might, you know, even if you know, with public domain books, okay, they might actually not have a library, even if it is just to contain public domain books. Okay, so it's a larger question when it comes to knowledge. I'll end here. Any questions?
See, you have a, say, Mona Lisa photograph. You take a digital photo, make it digital. So the moment you make it digital, it gets into machine language. So the machine language and the Mona Lisa are not similar.
Do you mean they're not similar?
Well, if you look at the machine language, what's there, and the Mona Lisa, nobody will say this is Mona Lisa.
So if you translate the Inuit into Tamil, okay, is that similar or are they?
I'm asking you. So it is. I mean, you can't say this is a copy on the face of it. So, and supposing you give the machine language to some other guy, and that guy sees the machine language and he runs it through a machine and produces a photograph, or alters that machine language at some point.
Sure. So
to make it a little different, which is not the same thing, and something gets produced which is 90%. So does copyright cover such?
So, interestingly, so think about the question of translations, because for me this fundamentally is a question about translation, but of a different kind, because you're talking about machine language, right? You're not talking about scanning or photographing, etc. Okay, so should translations be covered by copyright law? Should anyone be allowed to translate any work without permission of the person? What if the person isn't about to make a translation? So there's one kind of situation where someone is going to make a translation of an Italian book into English, okay, and doesn't want someone else to do that, you know, depriving them of revenue. But what if someone isn't going to do that? What if the publisher has no intentions of commissioning a translation? Then should a person be allowed to do it? No one is harmed. Sorry? Get permission. Okay. So in many cases, the people are dead. Okay. So and we have had situation where, for instance, James Joyce's son, Stephen, okay, was notoriously horrible to anyone who wanted to write anything about Joyce, you know, to scholars. So he denied them the permission to quote from James Joyce's books, okay, in their PhD thesis, in things like that. So I'm not sure that is what Joyce would have wanted himself. Okay, so it becomes a tricky issue. So I'll provide the answer since we're running out of time. Okay, but till around in the US, okay, till around the middle of the 19th century, translations were not regarded as copies. There's a famous case, or not so famous for those who aren't copyright nerds like me, I'm sorry, but there's a case involving a work by Harriet Beecher Stowe called Uncle Tom's Cabin. Okay. Now, in that case, a translation was made. Yet, the court held that a translation is the creation of a new work. It's not just mechanical, reproduction, but it is an artistic effort. You're creating something new. It is, as we're talking, it is actually a case of standing on the shoulders of giants. Okay. It is actually taking something that's existed before and creating something new, which is what all artists do. So in that case, the translation was held to be a new work. Yet, after that, copyright law has changed, created one more right to the existing array of what all copyright covers, okay, which is this new right of translation. And I'm sorry, I forgot to add one last thing in terms of what copyright covers. Now, there are things allied to copyright, okay, things like digital rights management, or what Richard Stallman calls digital restrictions management, okay, which in copyright terms is called technological protection measures. Okay, that I think Professor Arnachalam covered in quite some amount of detail, where he's talking about how with the digital, you actually aren't allowed to do a lot of what you are allowed to do with books offline. And there's one other reason for why with the digital you aren't allowed to do that which you are offline, okay, which is that online what you do is you never buy something, you license it. Digital content, go through how many of you have ever used the iTunes store or the Flight store or any of these things? Have you ever gone through the license? Have you ever gone through the thing to which you say, I agree? If you had gone through it, you would have realized that you actually don't own that song. You're actually granted a license to listen to that song. You pay the money and they allow you to listen to it. Okay? But you can't do all these other kinds of things. Okay? With that ebook, you actually can't do everything that you can with an offline book. You can't lend it to a friend. Lending it to a friend is perfectly legal in most jurisdictions around the world. Okay? Lending a physical copy that you've bought to someone else, and that book, selling it again, is also perfectly legal. But in many cases, because, and remember this distinction we saw, right, between the older copyright things and the newer copyright things, in many cases, lending a movie might actually be illegal, whereas lending a book might be legal. Okay, so there are all kinds of inconsistencies within copyright law. It is not actually a logical structure. And we're almost out of time. And
Is it allowed to? Maybe I can distribute something that I have bought from the online, purchased online. But is it allowed to give somebody the mechanism to reproduce it? Because I remember that there's this case registered where this guy who uploaded a song for somebody who was almost sued said that what I did was I compressed the file, so basically the person at the other end reproduced the file and I did not give it to him. So it was, I
didn't see how that would somehow be permissible. The thing that right now some companies are testing out in the US are these systems where you say you want to record something, okay? Someone else does the recording, okay, of that TV program, okay, in this case, okay? It's not recorded on your own hard drive, but you actually say you want to record it. And then you're allowed access to that. Now, if you press record, okay, and 5 other people press record, what at one point of time this company called eMusic tried to do was create one copy of a file, allow all 5 people who wanted to record it access to it. That was held to be illegal. Now what companies are doing is creating 5 copies, okay, and allowing people to do it, okay. Now again, this is going to court in the US, okay, with the argument that that is illegal. Now one case has been won by the people who were allowing this technology, but it's still a little bit uncertain, okay. So whether you can use someone else as an agent to do these kinds of things, it's still unclear. Because remember, when the VCR was first invented, that went to court. In the US, they allowed the VCR and said it was illegal. It was legal. Okay, it was fair use. In the UK, they said it was illegal. In 1989, in the UK, they held recording machines to be illegal. Okay, so we have all kinds of bizarre decisions, okay, which we're out of time, but if you want to keep people away from walking out of this door.
What about sharing music offline but using an online platform to contact each other, to know that this is the catalog list I have and I would share it offline? No, I have a video, I have audio CDs, I have a list of audio CDs on a platform, just a list, and I share it offline. I exchange it offline.
If you're sharing a list, then that's perfectly fine. If you're sharing files or if you're sharing music, that's not fine. So I haven't gone into lots of issues today, including the big issue of why on earth do governments who get taxpayer money and create something for the taxpayers, why do they get to own copyright and it not be in the public domain? Because with very few exceptions, most countries actually do have government copyright. Okay, so how does that work? And this again brings us to the question of how that Professor Arnachalam raised that when taxpayers fund research, okay, why does the results of that research not belong to the taxpayers? Okay, so there are lots more questions to be explored in this area. Sure.
Running any online tools like translators or re-narration tools over the web page is also like violating the copyright?
Until last year, search engines were illegal under copyright law of India. Okay, we specifically introduced an amendment last year to allow for search engines to be legal. Okay, so translation tools like that, I'm not sure. Okay, because technology is telling us one thing, that it's fine, but then technology is also telling us that embedding YouTube videos is fine. Okay.
Something like we translate a web page and we share the new page like in a local language. We take the page and
so one thing I can clearly say, under Indian law I can answer that. Okay, under Indian law the creation of the translation, if it is only for your use, is not illegal. Okay, because thankfully in India we have a fairly wide-ranging personal use right. Okay, but the moment you share that, it might become an illegality. Okay, so I would urge you to continue sharing it because it's very unlikely that someone's actually going to come after you for posting a translation of a news article on a mailing list. Okay, or if that's a problem, post a link to the Google Translate service itself. Okay, because you'd have a new URL that gives the translation.
but what if we have our own URL first? We generated URL like we pass on the website.
Then you better have lawyers as good as those that Google has. So I think it's kind of getting late. So up here, if you have any further questions, please, I'm going to be around this evening, so do come and talk to me.